Hello everyone, welcome back to SEBIGRADEB classes. I'm Rajni Yadav, and in today's class we'll be studying a subject tort, and we'll be covering this subject from the perspective of this exam as to what is important and what all points are important. That all we'll be covering this in this subject in today's class, and it will be kind of quick revision of tort that we'll be doing, right? So let's get started. What is tort? Actually, the word tort is derived from Latin term tort, which means to twist. A tort in French literally refers to a wrong. So the word tort is derived from the Latin term tort, which means twist. And in French language, it basically refers to a wrong. Any civil wrong which can't be categorized under breach of contract or breach of trust is a tort. A tort can be defined as a wrong independent of contract, giving rise to a civil remedy for which compensation can be awarded. So any civil wrong which is not a breach of contract or a breach of trust, it will fall under tort. It is basically what? It is a wrong. It is independent of contract, which will give a right to civil remedy for which compensation can be given. So tort can also be said to be something which is independent of contract, and when it is committed, it will give you a right to civil remedy for which compensation can be sought, right? Now, many jurists try to define tort, and we'll be studying two very important definitions and by two important jurists. First, we'll study Salmon's definition, and he says, a tort is a civil wrong for which the remedy is a common law action for unliquidated damages and which is not exclusively the breach of a contract or breach of trust or other merely equitable obligation. You should read this definition twice or thrice, and you will be able to do this. You'll be able to learn it. Actually, you should learn the keywords from a definition so that you should know who said or who gave what definition, right? Similarly, Winfield says, tortious liability arises from the breach of duty primarily fixed by law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages, right? So basically, whenever you're studying or reading definitions, what generally you can do is you can mark some important keywords from the specific definition, from the particular definition, and then you can learn by that. Say, suppose that is Salmon has said something about unliquidated damages, exclusively the breach of contract, and equitable obligation. So if you find these three words, you can easily say, yeah, this definition was given by Salmon, right? Now, the law of torts is created and developed by courts. As it is not codified in an act or statute, it has developed through the case laws and judgments, right? So basically, we don't find any legislation or act for tort, right? It is generally through this law of tort has basically developed through various judgments and case laws. So there is no particular statute or act which is governing this. It is actually a development of courts. It is actually a development through case laws by judges, right? Whenever a legal right vested in a person is violated by someone's act or omission, tort is committed. Tort is an important branch of law in common law countries like India, okay? And any person who's committing tort will be called as a tortfeasor. Now let's see what are the elements of torts. So there are basically three elements of tort, which are wrongful act, legal damage, legal remedy. So if you want to say something, or if you want to say that a tort has been committed, then you'll have to prove these things, that there was a wrongful act, and there was a legal damage that was caused to you, and now you want a legal remedy for that, right? So what is a wrongful act? When a person is under some duty, when a person is under some legal duty and he fails to perform it, causing some loss to the victim, the person has committed a wrongful act, right? A wrongful act invades the following private rights of the victim, like good reputation, bodily safety, legal rights, etc. Okay. Now, next is legal damage. There is a difference between legal damage and actual damage. It means an infringement of a legal right is punishable even if there is no actual damage. So, if you want to go in a court for a tort, you must prove that you had suffered some legal damage. Any damage will not make you eligible to file a case of tort. There should be some legal damage that has been committed against you, and legal damages, anything which means legal damage means any infringement for which there has been punishment provided, right, which is punishable. Okay. Now, third element is legal remedy. The damage in tort should be actionable. So there cannot be a tort if there is no legal remedy. So tort will only be there if some wrong has happened against you. If there is legal remedies there against it, then only it will fall under tort. Otherwise, it will not come under a tort. Now, let's see. Law of torts, or pigeonhole theory. Basically, now there's a confusion between people. They generally ask if it is a law of tort or law of torts. What exactly is the right word for this? What should we call it? Is it law of tort or law of torts? So let's start. Law of tort says, according to Percy Henry Winfield, he says law of tort, there is no S there. Law Winfield talks about law of tort is a general liability which originates from the violation of duty determined by the law. In other words, he means that for every wrongful act for which there is no valid justification, then the person is liable for committing law of tort. For example, when X hits his friend Y while walking on the road, then X can be liable for specific tort like assault, battery, nuisance, etc. If he committed any tort which does not have a particular name or category, still he would be liable for the tort. In this kind of interpretation, there is no need of specific kind of tort to be committed, only wrongful act which injures the third party, which would satisfy. In this kind of interpretation, there is no need of specific kind of tort to be committed. Only wrongful act which injures the third party would satisfy this theory of law. This theory of law of tort uses a broader approach, which helps to expand various decisions given by the court. Sir Winfield was in the favor of these kinds of new rules, which are created in the evolving society and help in tackling legal challenges on current issues. Law of tort is an evolving concept, as when new torts are identified, they are then incorporated in this theory. So first of all, what you should know is theory of law of tort was given by Sir Winfield. According to him, it is not and when we say law of tort, it's a very broader approach, and he says if any wrong is committed, it is not necessary if it has a specific name given to it or not. Right? If any wrong is committed for which there can be a legal remedy which can be sought, then he says by going by this principle and giving it a broader approach, then everything will be considered as a tort. So it is not necessary if something has a well-defined name as a tort or as any wrong which has been done against you, then only it will be punishable. No, he says even new wrongs can also be discovered and could be put under this category, right? So it is not necessary like we should have a particular torts by some name like nuisance, assault, battery. No, Sometimes it may happen, and sometimes it can even happen in future. According to Winfield, it may happen in future. A new tort is discovered, a new wrong is now made. So it can also be incorporated in this theory, that is law of tort. That is why he says it's a broader approach and it's an evolving concept, right? Now next is law of torts, which is also known as pigeonhole theory. This theory is formulated by Sir John William Salmon. In this kind of theory, not just wrongful act must occur, but that act must originate from specific, which is already established under torts. For example, X commits a wrong which does not have a specific name attached to it. Then X cannot be held liable for the same, right? This concept is very narrow and codified in the nature. Law of torts theory is also called pigeonhole theory. This theory is one of the most profound in the field of law, especially in law of tort, as in this theory, there is generally no principle of liability, and it's upon the plaintiff to put his wrong in a specific pigeonhole or specific law of tort to make the defendant liable. Right. According to this theory, the burden is always on the plaintiff to prove that the act of the defendant falls under the bracket of a specific wrong and not on the defendant to prove the other way around. Sir Salmon was one of the very few scholars who were against the idea of generalization of torts. He further noted that the remedy would be available for any wrong that comes under the well-constructed notion of torts, but only for such wrong. So first of all, you should know that this theory, that is law of torts, was given by Salmon. It is many times asked, who gave the theory of law of torts? Law of tort. The law of tort was given by Winfield, and law of torts was given by Salmon. You can also learn it this way, no? Tort and torts. Extra S is added in the torts, right? Salmon. S for Salmon, torts. S extra. So law of torts. And law of torts is pigeonhole theory. So according to Salmon, what he's saying that in this universe, we will be creating some pigeonholes. Like suppose this is the box, specific holes will be put in that box, right? So what will happen if a wrong is committed and that wrong has a specific name, it will fit into that hole, then that tort will be made punishable. If it does not have a specific name, then it cannot fit in that hole, then it will not be made punishable in that case. So what basically he's trying to say is that he is narrowing down what Winfield was doing. He was generalizing it. He was, giving it a broader approach. But Salmon is giving it a narrow approach, and he's saying if that tort has a specific name attached to it, if it is already recognized, then it will be fitting in that hole, and then only it can be made punishable. So Salmon was against the idea of generalization of tort, and he was giving the narrow approach. Just a second. Now, there are two foundational maxims of tort, or you can say two very important principles that we study in law of torts. The first one is injuria sine daminum, and the second one is daminum sine injuria. Let's study the first one, that is injuria sine daminum. This maxim literally means legal injury, that is injuria. When you read the word injuria, it means legal injury. Sine means without, and daminum means damage or loss. So legal injury without damage. So this maxim means legal injury without damage. Thus, cases of injuria sine daminum include those instances in which legal right of a person is violated, but as a result of it, he or she doesn't suffer any loss or damage. So legal injury was caused to you, was there, but the person did not suffer any actual loss or damage. Cases of injuria in damnum are actionable torts, right? So they are actionable and they will be made. So if you commit this, if any tort falls under this, then you will be held liable and you'll be given punishment for that. Therefore, the person suffering legal injury is entitled for grant of damages, that is compensation by court. So see, basically, first of all, here the punishment is always in the form of compensation, right? So whenever I'm saying you're made liable or punishable, you should know that legal damage will be given to you, and it is basically in the form of compensation that is given. Now let's read important cases with respect to this maxim, that is Bhim Singh versus the state of Jammu and Kashmir. So what happened in this case was a sitting member of Legislative Assembly was taken into custody specifically to deprive his right to vote. On a certain sitting in the assembly, he claimed that his right to vote in the assembly was infringed. The Supreme Court held that the police acted maliciously in arresting the petitioner, even though there was no monetary damage to him. He is entitled to bring a cause of action as a result of his right being violated. He was awarded 50,000 as a compensation. Right. See, the assembly was, it is our legal right to vote. We all being in Indian, we all have the legal right to vote. His legal right was violated. He was deprived of from casting his vote. So he claimed that his right to vote was infringed. Supreme Court held that since his legal right was damaged, even though his Supreme Court said his legal right was violated, even though no remedy, no damage has actually occurred to him, but still he will be getting the compensation, right? Because the person he was wanting to vote now actually won. But so that is why his legal right was violated. He was not given the right to vote. And but no damage was caused because the person he was wanting to vote was actually won. But still he was given compensation by the court. Second case is Ashby versus White. It is asked many a times. Ashby versus White relates to which principle, which maxim? So you should know Ashby versus White relates to injurious in damnum. So it is a similar case on the same principle, wherein as a result of deprivation of a person's right to vote, the court allowed him to seek damages. The law does not only regard damages, but looks into violation of legal rights of an individual, irrespective of consequences. Now, the next maxim that we have to study is damnum sine injuria. It means, this maxim literally means damage, damnum, without sine, a legal injury, right? So, damnum means damage, sine means without, injury means legal injury. So, herein it means damage was caused to you, but there was no legal injury. There was some actual damage which you suffered, but there was no legal injury to you, right? So such cases are not actionable torts, and the plaintiff is not entitled to damages or compensation despite the fact that loss has been suffered to them. So even though you will suffer some loss or injury, I mean to say some loss or damage, but still you will not get any compensation in these cases, and these cases are not actionable torts. Because the most essential element of a tortious liability to arise is legal injury that is missing. See, basically the main element in tort for you to get a compensation is legal injury. So the court will always look into it if you suffered any legal injury or not. If the legal injury is proved or it is there, then only you will be getting damages, that is compensation. Otherwise, court will not grant you or give you any damages, that is compensation. See, there is a difference between the word damages and damage. when we say damage, it means some harm, some loss has occurred to you. But when we say damages, it means compensation, which is money, which is in a kind of monetary form, which you get. So damage is some harm or loss suffered by the party, and damages is compensation, which you get from the court. You should know this difference. So important case law in this is Gloucester Grammar School case. Facts are, one of the teachers of a school quit the school and started a new school close by, which caused loss to the previous school. He was sued for damages. Although there was a substantial physical loss to the previous school, there was no violation of a legal right, and hence no cause of action persisted and no damages were given to him. See, basically everyone has a right to do profession, business, trade. This is a legal right which has been provided to us by our constitution. So opening a school can never be against legal right. So when the case was filed against that person for opening a new school, even though the previous school suffered loss, but still it was not a legal injury that was caused to him. He did suffer some damage or loss because of the opening of new school, and being the competitor in the same area, he must have suffered a huge loss. But still, it will not be considered as a legal injury. The court will not recognize it as a legal injury and will not grant you any damages for that. Right. Now let's see. Now let's read the difference between these two terms, that is civil wrong, which is also a private wrong, versus crime or public wrong. So let's read the difference between these two. Civil wrongs are also called private wrongs because these wrongful acts are committed by one individual against another individual, and the state has no role to play in it, because there are disputes among private individuals. On the other hand, crimes are called public wrongs because these include those wrongful acts that don't affect only the particular individual, but the society at large is affected. Right? So basically, whenever you see, if it is a civil wrong, right, it is generally A versus B, Shyam versus Ram, something of that sort. Basically, civil wrongs are private wrong in which the rights of an individuals are affected, and they are seeking some remedy which is just related to them, which will just give compensation to them. But whenever there is a crime or whenever there is a public wrong, crime, they are basically big wrongs like theft, murder, something of that sort. Generally, the interest of state is included. Public at large is there, whose interest is affected. Suppose if there is a murder in the society, of course, it will affect everyone in the society. So herein the role of state comes, because the state is the protector of, state is the protector of every citizen. So the role of state comes here. So that is why in these cases, so generally in criminal cases, you will always find it is against state of, let's say, Mithu Singh versus state of Punjab, something like that, A versus the state of UP. So when it is a criminal, it is a crime, or it is a public wrong, a large interest is included and it is affecting the public at large. So generally, state is involved in that. So generally, these cases will be A versus state of X, A versus state of Y. It is like that. It is on this principle only. In cases of civil wrongs, the primary remedy is compensation in cash or in kind, because its motive is to restore the previous position of the wronged person, while in criminal cases, the primary remedy is imprisonment, because the motive is to punish the wrongdoer. So yeah, in civil cases, you will give them compensation, damages are given in the form of compensation, and in criminal cases or in public wrongs, generally what you're doing is you are giving imprisonment, so as to punish the wrongdoer, so as to deter that person so that he does not repeat it again. But in civil wrong, what we are doing is we are giving that person compensation so as to put him back to his earlier position, right? In civil cases, both the parties to the suit are private parties, and however, the state may be plaintiff as well as defendant, but it is not compulsive and depends upon the case. However, in criminal cases, the state is always prosecution and it can never be the defendant, right? Because see what happens in criminal state, big crime, big offense happen, dacoity, theft, murder, everyone's interest is involved. So whose duty is it to protect us, all the citizens of this country? It is a state's, no? So you can't go alone. Generally, the cases are taken by the states. So states are involved in criminal cases. Now we will be reading types of torts. There are many types of torts. We'll be covering important torts in this class. The first tort that we'll cover is trespass. And it is an unreasonable interference of the property, land, person, or goods. In trespass, the legal right of the owner is infringed because he is deprived of his right to enjoy the benefit of the property by misappropriation or exploitation of his right. There are basically three types of trespass. That is trespass to person, trespass to land, trespass to goods. So what is trespass to person? When someone interferes or harms, or when some interference or harm is caused to the body of a person, it is called trespass to person, right? When some interference is done with respect to your body, with respect to the body of a person, it is called trespass to person. It is an invasion of person's right to freedom. So basically here you're infringing with the person's right to freedom. It consists of following torts: assault, battery, or false imprisonment. Example: slapping someone or pointing a gun on someone. Now the third one, this is second one. Trespass to land. It is an interference with the possession of land without lawful justification. Trespass can be caused by a person himself entering the land, or another person, or doing the same through some material object. Going beyond the purpose for which a trespass has entered certain premises, or crossing a boundary where he has authority to go, amounts to trespass, right? So when you're trespassing against the land, basically you're infringing into your suppose there's a plot of land, you're not allowed to go there, you don't have the permission to go there, but still you are going, you're interfering with the other person's right to land or right to enjoy the property, you're interfering in that person's right to possession. So basically what you're doing, this is called trespass to land, right? Because you do not have the authority to go. And suppose if you had the authority to go to that particular piece of land, but if you go beyond that land, then also it will be called trespass to land. Trespass to goods. It is the interference with the goods which are in plaintiff's possession without any lawful justification. So when you are interfering with the goods which are in plaintiff's possession without any lawful justification, it is called trespass to goods. Goods can be referred to personal property, whether movable or immovable, except for land. Mistake of ownership cannot be used as a defense. Like two friends are studying together. After studying, B took the book of A, assuming it to be his book. Here in this case, the mistake of ownership cannot be taken. If the defendant is wrongfully detaining the goods belonging to the plaintiff and refuses to deliver the same on lawful demands, the plaintiff can never recover the same by bringing the action. The plaintiff can recover the same by bringing the action of detenue. So herein there is actually talking about a new term. What is detenue? So they can ask, right? So what is detenue? Detenue is basically when you're detaining the goods belonging to the plaintiff and refuse to deliver the same on lawful demand. Suppose you give me your mobile, or suppose you give me your watch to, uh, you give me you lend me your watch. Okay, you wear it for 2-3 days, and whenever you wish, you can return it back to me, or I'll ask it from you whenever I want. Right now, what happens? You ask for your watch from me after 7 days, after 1 week, but I'm not giving it back to you. So so now how you can recover? You can recover the same by bringing an action of detenue. So the property which I'm holding is against the lawful demands. So now when you bring the case against me, it will be bringing an action under the tort of detenue. If a person willfully and without any justification converts the goods of another who is entitled to immediate use and possession of the good, then the person is liable for conversion of shatter. Right? So this is called, this tort is called conversion. Right? I gave you some good for some other purpose, but now you're using it for something else. Right? So this is called conversion. Now we'll be studying battery. As we all know, under trespass, we read about assault, battery, false imprisonment, various. These are also basically kind of trespass only. So now we'll be studying battery. What exactly battery is? Let's see. When some physical force is applied to another person in some offensive manner, which causes some harm. When some physical force, so you should focus on this word. When some physical force is applied to another person in some offensive manner, which causes some harm, physical force, some harm, it is said to have committed battery. Battery refers to the intentional use of force on another person without any legal justification. If the party did not intend to injure the other person, but he knows that his act could injure someone, then also the battery is committed. Hitting someone on the face, beating someone with the bat are some of the common examples of that. Right. So now let's see what are the essential elements of battery. They are use of force and without lawful justification. Right. There must be some use of force to bring the wrong under the tort of battery. Even if the force is trivial, there is no harm. The wrong is still committed. Right? Physical hurt is not necessary. Least touching of another in anger is a battery. Slapping a person, using a stick to beat someone, throwing of water, or spitting on someone are examples of use of force. Right? So these are some examples of battery. Without lawful justification. It is also essential that the use of force is intentional and without any lawful justification. Harm suffered due to the voluntary action of the plaintiff does not come under battery. Harm which is unintentional or caused by pure accident is not actionable. Like in a narrow tunnel, one person accidentally touches another gently, it does not come under battery. However, if the touch is rude or inordinate or in an inordinate manner, then it is actionable. Right? Now let's read what is assault. In assault, there is a reasonable apprehension. So this is the word. Reasonable apprehension is there in assault of the infliction of a battery upon another. When the act of defendant creates an apprehension in mind of plaintiff that he is going to commit battery, the wrong of assault is committed. So basically, assault is a stage before battery, wherein it says if the defendant creates an apprehension in the mind of plaintiff that he is going to commit battery. If there is an apprehension which is created in the mind of plaintiff that the defendant is going to commit battery against him, then the wrong of assault is completed, right? Suppose I make a fist like this. I make a fist like this. So there is an apprehension will be made in front of the person who's. There will be apprehension in front of. There will be apprehension to the person who's standing in front of me, right? That this person is going to use force against me. So the moment I make gesture like this, then it will be called an assault, right? Pointing a gun at someone, whether loaded or unloaded, creates an apprehension in the mind of the person on whom the gun is pointed. Hence, the wrong of assault has been committed. Okay. Now let's read what are essential elements of assault. Intent to cause apprehension. If the victim proves that there was reasonable circumstances to believe that the tortfeasor, person who commits a tort, is about to cause harm, the tort of assault is committed. Imminent harm. There must be an imminent danger to the plaintiff. There must be prima facie ability to do harm. Like if fist is shown from such a distance that threat cannot be executed, then there is no assault. So basically, what is the difference between assault and battery? Assault, battery follows assault, right? First there is an assault, then only battery will come. In battery, there is a physical force, use of physical force is there, right? Some touch is there, some intentional touch, body touch is there. But in assault, there is an apprehension in the mind of plaintiff that the defendant is going to cause some harm, right? So suppose if a person is going to sit on a chair and the other person pulls it before he's about to sit. So as long as that person is in the air, it will be an assault. The moment his body touches the ground, it will become battery, right? Similarly, in the case of spitting, if a person is spitting, the moment your spit is in the air, it is the stage of assault. The moment spit touches any body part of the other person, it will become battery, right? And in the case of assault, the apprehension that is caused in the mind of plaintiff, it must be, it should be from such a distance that reasonable apprehension is created in the mind of a plaintiff. Suppose that person is like saying it on phone that I'll come and I'll give you a tight slap, etc., something like that. Then it will not be an assault. Imminent harm should be there. That person should be in the proximity to hit and cause reasonable apprehension in the mind of plaintiff. Then only it will be called as assault. Now, the next tort that we will study is false imprisonment. False imprisonment. In false imprisonment, it means imposition of a total restraint upon the liberty of the person for a shorter period and without any lawful justification. That means when a person is deprived of his personal liberty by being confined within four walls or by being prevented from leaving the place where he is, then also it comes under the false imprisonment, right? So the essential elements of false imprisonment are total restraint at the liberty of a person, means of escape, right? Example, if the window providing escape is so high that it can cause injury to the person detained, then it will come under the false imprisonment. So basically what they're saying under this tort is that if there is a total restraint in your freedom to move, then it will come under the tort of false imprisonment. And you should not have, if in case you have means to escape that place, then it will not come under false imprisonment. So there should not be any means of escape, and it should be total restraint in your liberty to move. Then that wrong will be termed as false imprisonment. Okay. Now, next tort that means studies negligence. Negligence is an absence of reasonable care which is imposed on all the persons so that no harm is caused to the person. Basically, what they're saying is, in the tort of negligence, there is absence of reasonable care. Right? The burden of proof should be on plaintiff that the defendant was most likely negligent. So burden of proof is on the plaintiff to prove that defendant was negligent. For example, Rohan, an owner of a big dog, leaves his dog unattended, who attacks a passerby, badly injuring him. In this case, it can be said that the act of Rohan was negligent, right? Now, let's see what are the essential elements of there is some, no, this is actually something wrong. It should be, wait, this is essential elements of negligence, right? There is some mistake in this file. So let me give me a second. Yeah. So essential element of negligence. They are duty of care, right? In this, the first most important element of negligence is duty of care, right? There's a duty of care, that is, the defendant must owe a duty of care to the plaintiff. The plaintiff has to establish that the defendant owed a specific legal duty to take care and he has breached that duty. So the first important essential element of negligence is duty of care, right? It was the duty of the defendant that it was a duty on defendant to take care of the plaintiff, right? Sometimes the relationship between plaintiff and defendant automatically creates a legal duty or obligation to act in a certain manner. Like doctor owes a duty to care to treat the patient in an appropriate manner. And the second duty is breach, and the second essential element is breach of duty. Karen, what actually it is that first of all, there was a duty of care, then there was a breach of duty. That is to say, the defendant made a breach of the duty. The defendant can be held negligent if he knew that his action would affect the other person. If he does not act in a correct way, like if the defendant knows that his dog is ferocious, then he should put some warning sign outside his house, like beware of dog. If he fails to do it, then he is negligent, right? And the third is damage. Some damage must have been caused to the plaintiff. So by damage, the plaintiff must have suffered some damage due to the act of defendant. So it is important to prove that the defendant's breach of duty caused some damage to the plaintiff. The plaintiff has to show that the damage is not to remove. The duty to access the damage is entirely the discretion of the court. So basically what we have to see, there are three important elements or essential elements of the tort of negligence that you have to see is, First, that there was a duty of care on the defendant and there was a breach of duty of care. First, there was a duty of care on defendant and there was a breach of that duty of care by defendant and some damage was caused to the plaintiff. So if these three elements are fulfilled or proved, then it will fall under the category of tort of negligence. Very important and landmark case on this topic is Dunnog versus Stevenson. So you must know this case name, that this case relates to negligence. Facts. Dunnog drank from a ginger beer bottle. This case is also known as ginger beer bottle case, right? Dunnog drank from a ginger beer bottle bought by her friend, which contained the contents of a dead snail. It was not visible due to the opaque bottle. The appellant suffered from shock and gastroenteritis. She sued the defendant, Stevenson, who was the manufacturer of the bottle, right? So what court held in this case? Court said that the manufacturer was found liable to Dunnog. As a result of his decision, a party could claim damages from another, even though there was not an express contract between them. It was held that the defendant had a duty of care and a violation of that duty invited cause for legal action. So when the case was put against Stevenson, who was the manufacturer, he said in his defense that he did not have any contract with Dunnog. So court said still you will be liable because you owe a duty of care towards your purchasing, right? Because everyone who's consuming that drink from that bottle, of course, would be presuming that I'm drinking everything which is safe to drink. So of course, you owe a duty towards every consumer, that whoever is consuming your product, and there was a violation of that duty by you, and the person suffered some loss. Therefore, the manufacturer, that is Stevenson, was held liable under this case. So when you study negligence, there is a very important maxim which is there in this thought, that is res ipsa loquitur, which means things speak for itself, right? In the law of torts, to prove somebody's negligence, the burden of proof is on the plaintiff, which means the person who is the victim of the tort, right? So in the case of negligence, the burden of proof is on which party? It is on the party who has suffered some loss, and that party is plaintiff. So it becomes really very difficult to prove that the defendant was actually at fault, and also to gather evidence against his act or omission. So definitely it becomes difficult to gather evidences against the defendant. So if the plaintiff is not able to prove negligence on the part of the defendant cannot be made liable, right? So if the plaintiff is not able to prove negligence on the part of the defendant cannot be made liable. Of course, to make anybody liable, you will have to prove that he has done something wrong. Then only you can make him liable, no? So the principle of res ipsa loquitur came into force, under which a plaintiff can use circumstantial evidence to establish negligence, right? So the principle of res ipsa loquitur came into force, under which the plaintiff can use circumstantial evidence to establish negligence. So the maxim of res ipsa loquitur applies in situations like the cause of the accident was under the management or control of the defendant. The accident is such as in the ordinary course of things would not happen if those who have the management or proper use care, right? The accident is such as in the ordinary course of things and would not happen if those who have the management use proper care. So there's a case related to this. Karnataka State Road Transport Corporation versus Krishnan, 1981 case. In an accident, two buses rushed each other in such a way that the left hands of two passengers traveling in one of these buses were cut off below the shoulder joint. it was held that the accident itself speaks volume about the negligence on the part of drivers of both vehicles, right? So the doctrine of res ipsa loquitur was applied to the case, and in the absence of any satisfactory explanation, the defendants were held liable, right? Now, in negligence, you will there are two kinds of negligence: contributory negligence and composite negligence, right? So, what is contributory negligence? In certain cases or circumstances, a person who has suffered an injury which will not be able see. In certain cases, a person who has suffered an injury will not be able to get damages from another for the reason his own negligence has contributed to his injury, right? Every person is expected to take reasonable care of himself. So in contributory negligence, what basically they're saying, every person owes a duty towards himself also to take proper care of himself, right? So there may be circumstances, a person has suffered some injury and he will not be able to get the damages from another person because some negligent act was done by that person also, right? So example, if the conductor of a bus invites passenger to travel on the roof of the bus, and one of the passenger traveling on the roof is hit by the branch of a tree and falls down and gets killed, there is not only negligence on the part of the conductor, but also contributory negligence on the part of the passenger. So this is what they're talking. See, suppose there is a bus going on which is already filled with passengers, but you still stop that bus and talk to the conductor or the bus driver and ask to give you lift on the head of the bus, right? On the roof of the bus. So now if the driver puts the brake, of course you'll fall down. And if injury is suffered to you, you cannot come to the court and ask for compensation because herein you also contributed to the accident. You were also negligent. So in this case, apart from the negligence of the driver and the conductor, you were also negligent. So therefore, this is the case of contributory negligence, right? Next is composite negligence. When the negligence of two or more persons results in the same damage to the third person, there is said to be a composite negligence. That is, when the negligence of two or more persons result in the damage to the third person, it is said to be composite negligence, right? And the persons responsible are known as composite tortfeasors. In the case of contributory negligence, there is negligence on the part of the defendant as well as the plaintiff. Plaintiff's own negligence contributes to harm which he has suffered, right? In the case of composite negligence, there is a negligence of two or more persons towards the plaintiff, and the plaintiff himself is not to be blamed. While contributory negligence is a defense available to the defendant to overcome or reduce the liability in relation to the defendant, in relation to the plaintiff. The composite negligence is not a defense. So basically, contributory negligence can also be used as a defense by the defendant when being asked to pay compensation to the plaintiff. The defendant can always say that there was a negligence on the part of plaintiff also, so his punishment, as in the compensation that he's being asked to pay to the plaintiff, that will be reduced if there is a contributory negligence. But in composite negligence cannot be used as a defense. Basically, in composite negligence, what is happening? Suppose there is a road. It has, it's a junction from it has 4 lanes are there, and the person is coming and all 3 cars hit him, right? It was not his fault. So this is what they're talking about, composite negligence. That is, 2 or more persons are hitting the third person. So composite negligence therefore cannot be used as a defense because here the plaintiff was not at all at fault, right? So this is it for today's class. The remaining law of tort we'll be covering in the next class. I hope you liked and understood the session. So thank you.